Hello, everyone, and welcome to the Teske Brief. I'm Judge Steven Teske, retired, and in this series titled The Bar Card and the Breakdown of Justice, we examine one of the most important stories in American law and government today. What happens when the lawyers entrusted to enforce justice begin to fear the very system that they serve? Now, across this series, we've been exploring and will continue to explore why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, and why independent courts and state bars still matter, and what is lost when institutions ask for power but stop earning trust. This is not a story about personalities alone. No, ladies and gentlemen, it is a story about professional duty, constitutional guardrails, and whether the rule of law can withstand the pressures placed upon it. This is episode 4, and it's titled, The Rules They Swore to Follow, where we take a deep dive into the ethical rules governing the conduct of lawyers in the practice of law, and that includes all prosecutors, including those at the United States Department of Justice. So before we begin, remember this: titles are temporary, power is borrowed, integrity is tested when pressure arrives. And this is the Teske Brief. Welcome back. Every profession has rules. Pilots are supposed to land planes, doctors are supposed to help the patient, firefighters are generally expected to prefer water over gasoline, and prosecutors, well, they're supposed to care about evidence. Which brings us to today's episode, the rules they swore to follow. Now, we've talked about what a real prosecution looks like. Now we need to ask a harder question. Where do those standards come from? Because fairness, restraint, honesty, and independence are not just nice ideas people print on courthouse brochures. They are professional obligations. They are real rules with real consequences. Just ask Rudy Giuliani and Cheesebro, and John Eastman and Miss Ellis. Look, Lynn Wood, and the list goes on. They have real consequences. They have been disciplined, some of them disbarred. A lot of people think prosecutors are just government lawyers trying to win cases, right? But no, that's too small. Private lawyers represent clients. Prosecutors represent the public interest. That's the difference. That's why ethics rules describe prosecutors not merely as advocates, but as ministers of justice. And let's admit it, that sounds like the world's least fun superhero. No cape, no gadgets, just disclosure obligations and probable cause. But the phrase matters because it means the job is bigger than winning. It includes fairness, candor, restraint, and protecting the innocent. Now, let's start with the obvious rule that apparently needed a reboot. You do not bring charges you know are unsupported by probable cause. That's black letter ethics. There must be facts supporting a reasonable belief that a crime occurred and the accused committed it. Not vibes, not rumors, not my Uncle Saul post, not the boss is really upset. Facts. Because once evidence becomes optional, everyone becomes vulnerable. Another rule prohibits conduct prejudicial to the administration of justice. Translation, right? Do not use your law license to damage the legal system itself. Do not weaponize public power. Do not turn the office into intimidation. Do not treat fairness as an obstacle. Again, these are not suggestions of a meditation app, right? They are enforceable standards, which brings us to the awkward part. Recent reporting says that White House Chief of Staff Susie Wiles acknowledged that some prosecutions were tied to score settling and retribution. That's what the president wanted.
Wiles reveals there was a loose agreement with Trump. Score settling would end after the first 90 days in office, but reality didn't follow the script. Trump continued to publicly pressure his Justice Department, calling for prosecutions of critics, including former FBI Director James Comey, New York AG Letitia James, and Democratic Senator Adam Schiff. even posting on Truth Social that they were all guilty as hell. Here's what followed. Federal courts dismissed indictments against both James and Comey, not on technicalities, but because the prosecutor was found to be unlawfully appointed. Then grand juries refused to indict again. And yet, as NBC News reports, prosecutors insist there should be no premature celebrations. The message: the door isn't shut. Wiles doesn't argue these actions don't look vindictive. On the Comey case, she admits, people could think it does look vindictive. I can't tell you why you shouldn't think that.
Then there's Ed Martin. Mentioned him as well in the last episode. Reportedly said that if certain targets could not be charged, they would still be named and shamed, even without sufficient evidence to prosecute.
There are some really bad actors, some people that did some really bad things to the American people. And if they can be charged, we'll charge them. But if they can't be charged, we will name them. And we will name them. And in a culture that respects shame, they should be people that are shamed. And that's a fact. That's the way things work. And so that's how I believe the job operates.
That's just not traditionally how a job within the Justice Department does operate. But,
Wow. Now, if that reporting is accurate, we have drifted far from Minister of Justice and alarmingly close to petty tyrant with office stationary. Because public humiliation is not a substitute for proof. And we can't prove, but let's damage them anyway. That's not a legal doctrine. It's a confession. It's a confession you're being unethical. And none of this is new. We can go way back to 1940 when Attorney General Robert Jackson, later to become Justice of the Supreme Court, warned that the greatest danger of prosecutorial power lies in officials picking a person they dislike and then looking for an offense. 80 plus years later, that warning still feels fresh, which is impressive and depressing. So why would lawyers risk it, right? Because power is immediate. Consequences are often delayed. The promotion is now. The appointment is now. The praise is now. But what about the bar complaint? Well, you see, folks, that may very well come later. And it has for Pam Bondi down in Florida. See, after the cameras leave, after the administration changes, after the loyalists discover loyalty was not reciprocal, ask some of the lawyers sanctioned or disbarred after filing false election fraud claims. The political moment expired, folks. The disciplinary record did not. So the real choice for government lawyers is not always follow orders or get fired. Sometimes it is keep the title now or keep the license later. And that is a brutal calculation no ethical system should force on its lawyers. Now, why should citizens care about any of this? Because these rules are among the last safeguards standing when politics pressures law. You may never see the internal memo. You may never hear the private conversation. But later someone can ask, was there probable cause? Was the conduct fair? Was the offense abused? That's what rules do. They preserve standards when memory gets selective.
There is nothing normal about a president of the United States directing prosecutions or investigations via social media. And no matter who you voted for, you should not normalize this idea of a president using social media or any platform to direct the Justice Department to investigate anyone. Now, a lot of focus has come out in these last days over who the president was directing the Justice Department to open investigations into. Bill Clinton, JP Morgan Chase, Lawrence Summers. It's not who, it's the fact that he was doing it at all that ought to be quite concerning. Now, even though the president oversees the Justice Department and it's part of the government, there is a long tradition of presidents not directing the Justice Department to do anything, to investigate or prosecute anyone. That started after Watergate in the 1970s, not just as a way of preventing the kinds of abuses that Richard Nixon engaged in and may have been prosecuted for, but also as a reminder of who we are as Americans and how our government ought to work. We are not a country, or have not been a country, in which the president puts a thumb on the scale and directs people to be prosecuted. There are many places in the world in which heads of state routinely direct prosecutions or investigations into people. That's certainly not who we have been as a country, and quite frankly, in instances where people have made that suggestion about presidents, there's been huge public outcry. Social media has made it very easy for presidents and other political leaders to put even policy out into the world. This type of policy, directing investigations and prosecutions, is one bit of policy we should not get used to hearing from any president, whether it's President Trump or another president in the future.
This series has covered lawyers leaving, judges pushing back, loyalty tests, and collapsing trust. Those are symptoms. The ethical rules reveal the disease. When prosecutors ignore evidence, substitute humiliation for proof, or confuse loyalty with duty, they are not just making controversial choices. They are breaking the rules they swore to follow. All right, ladies and gentlemen, I'm Judge Steve Teske, retired, and this is the Teske Brief. Remember this: power can excuse almost anything in the moment, but ethics tends to revisit the file later. Now, until next time, y'all be safe and take care. Bye.